Welcome to a special crossover edition of the Consumer Finance Podcast and Payments Pros Podcast. I'm Chris Willis, the co-leader of Troutman Pepper's Consumer Financial Services Regulatory Practice. And today, Josh McBeain, one of the hosts of Payments Pros, and I are going to be talking with two guests about the CFPB's interpretive rule in which it has decreed that buy now, pay later transactions are actually credit cards. But before we get into that topic, let me remind you to visit and subscribe to our blogs, TroutmanPepperFinancialServices.com and ConsumerFinancialServicesLawMonitor.com. And don't forget about our other podcasts. We have the FCRA Focus, all about credit reporting, our Crypto Exchange podcast, which is all about crypto, and Unauthorized Access, which is our privacy and data security podcast. And launching soon, look for Moving Metal, which is our new auto finance podcast hosted by Brooke Conkle and Chris Capurso, members of our Consumer Financial Services team. All those podcasts are available on all popular podcast platforms. And speaking of those platforms, if you like this podcast, let us know. Leave us a review on your podcast platform of choice and let us know how we're doing. And if you enjoy reading our blogs and listening to our podcasts, our mobile app is a great way to do that. It has access to all the blogs and podcasts in one place, and even a great directory of all of our financial services lawyers. It's available for both iOS and Android. Just go into your app store and search for Troutman Pepper, download it, and give it a try. Now, as I said, Josh and I today are co-hosting this episode, and we have two of our colleagues on board to talk about the CFPB's recent interpretive rule in which it decreed that buy now, pay later transactions are actually credit cards, subject to at least some of the provisions applicable to credit cards in Regulation Z. And joining us to talk about that today are Mark Furletti and Jason Cover. Mark, Jason, thanks for joining us on the podcast today.
Thanks, Chris.
Thanks, Chris.
This is a really juicy topic, and I'd really love to ask the questions, but I think I should yield to you, Josh. Why don't you ask what questions are burning in your mind about this seemingly very interesting and controversial interpretive rule?
Thank you, Chris. I would love nothing more than to talk about defined terms of Regulation Z with Mark and Jason. So I'm going to jump right into it. So how exactly has the CFPB reinterpreted Regulation Z's defined terms to subject a close-end buy now, pay later transaction to Regulation Z's credit card requirements?
I guess, Josh, first and foremost, they've created this new term called a digital user account. And when you have a digital user account, you thus have a credit card. I mean, then this is obviously all brand new. Importantly, however, digital user account isn't really defined by the rule. So we have this kind of nebulous term, and the CFPB has helpfully provided some examples or some suggestions as to what a digital user account might be. And they say, for example, that it's a secure profile that the BNPL provider activates for the consumer. Once activated, the account can immediately be used on an ongoing basis to access BNPL credit to make purchases. The account is typically associated with an amount available to spend. It is akin to the credit limit of a traditional credit card. And the use of the account is frictionless borrowing process that allows consumers to rapidly access BNPL credit. So that's sort of, I guess, what we know, but we don't really have a precise definition that we can, like, for example, advise our clients and tell them, yes, you are definitely using a digital user account with your product, or you're not. We just kind of have this, suggested use case here where, you're buying products on credit with some sort of account that someone accesses.
Thank you, Jason. So as I understand it, if a buy now, pay later provider is offering a digital user account, they may be subject to Regulation Z's requirements for credit cards, which are numerous. So are there any specific ones? Did the CFPB provide, any more specificity on that, or is it all the credit card requirements?
So, Josh, the press release and everything seems to suggest that they were mostly caring about ensuring that consumers using buy now, pay later products had the ability to get access to dispute rights with merchants. So, there's billing error resolution rights under the Fair Credit Billing Act for when a consumer experiences, a merchant perhaps that charges them the wrong amount or overcharges them or something along those lines. And for the most part, that's what the, at least in the press releases and in some of the public pronouncements of the CFPB, that's been the focus. But of course, as you noted, the requirements under Reg Z are just, there are many, many of them, and they can be quite onerous. So what I was hoping to do is briefly discuss kind of how there are different requirements that apply to different types of, quote, credit cards. And so let me start by just briefly outlining, if you look at the definition of credit card in Reg Z, in 1026.2A15, you'll see that there's a few different definitions there. And one of the definitions is what I call a Card Act credit card. And Reg Z calls that a credit card account under an open-end, not home-secured consumer credit plan. Very pithy, defined term. And so that's the Card Act credit card. And most people are very familiar with Card Act credit cards. They're the ones that they probably carry in their wallets today that allow them to make purchases at various merchants. And then if they want to revolve the balance, they can. And so those are generally attached to open-end credit. And, those kinds of products, they're both subject to Subpart B and Subpart G protections under Reg Z. And so what that means is there's the solicitation disclosures and account opening disclosures. They get periodic statements. There's liability limits. There's claims and defenses, ability to assert claims and defenses against the card issuer that you can assert against the merchant. And there's billing error resolution. And on top of all that, as a consequence of the Card Act, there's also these other protections that relate to ability to repay and first-year fee limits and posting the agreement on the internet, et cetera. Okay, so that's kind of the full-blown, that's about, all of the provisions that could potentially apply, I'd say, apply to the Card Act credit card, at least the credit card-related ones. Then you have another definition in Reg Z for a charge card, and a charge card ends up getting treated like 90%, it's like 90% is burdensome as a Card Act credit card. So the vast majority of the requirements that apply to a Card Act credit card apply to a charge card. And then we have, let's say, a non-Card Act, non-charge card credit card. And that's what this rule purports to make the digital user account that Jason described. And so a digital user account, what protections does it get? It doesn't get those Subpart G protections under the Card Act, generally speaking. It doesn't get the ability, you don't have to do an ability to pay analysis. There aren't limits on the first year fees, at least as traditional. This is talking about traditional buy now, pay later, and posting of agreements don't have to do that.
Importantly, the new late fee rule, if it went into effect for credit cards, would not apply to this type of credit card.
That's right. Yeah, because those late fee limits are in Subpart G, and so they're not going to apply. But where that leaves you with respect to this kind of non-Card Act, non-charge card credit card is you have to comply with Subpart B, which, account opening disclosures, periodic statements, limits of liability, billing error, all that. And then on top of that, you may, depending on the credit, have to additionally comply with Subpart C. Again, depending on what the product is. If it's a traditional buy now, pay later product, then you wouldn't have to because there's no finance charge. And because traditional buy now, pay later is a 0 APR product. But, the Subpart B requirements are really onerous. I would say the periodic statements are really, really difficult to kind of create. That's an area where, most clients will take months to develop their periodic statements because, they're doing lots of testing just because they're pretty challenging. And then the other issue here is most of these products, the providers think of them as kind of like, oh, there's one buy now, pay later transaction. Oh, now there's another buy now. They think of these things as separate transactions. And, clearly when you have a billing statement and you try to bring them all together into one place, what does that do? You also have like potentially different payment due dates. And so, I think that part of it it could be fairly challenging. But fortunately, as Jason is going to tell us a little later, there's ample time, right, Jason, for buy now, pay later providers to deal with all this new burden.
And I guess, Mark, just to sort of add insult to injury, and I know our colleague Josh has gone through this process with us, you'll have to go through Subpart B piecemeal, and it's not always clear, this is intended for open-end credit, and we're talking about closed-end credit. And it's not always clear what provisions apply to a closed-end credit card. There's various references to open-end credit. There's references to Card Act cards. There's references to creditors. And you sort of have to parse through all this and sometimes just make some risk-based decisions about what is or isn't applicable under Subpart B to a quote-unquote closed-end credit card.
And to that point, Jason, in the interpretive rule, the CFPB mentions dispute rights and billing statements, that they find those important, and those are subpart B rights that they want certain BNPL transactions to have. But there are account opening disclosure requirements in subpart B, aren't there?
Yes. And I honestly think, I don't know if the CFPB missed that, but I do worry based on some of the representations in the industry that folks are largely glossing over all of these other, whether it's periodic statements, account opening disclosures, all of these other things they need to do. You may not just be able to rely on your current consumer facing agreements. You need to give it a close look and check. And again, that gets to Mark's point about timing. All of this is laborious and time intensive.
Well, thank you both. I know the CFPB, they characterize this as an interpretive rule. They are reinterpreting some of the definitions in Reg Z to get to this conclusion. But is that name, interpretive rule, is that proper in this instance?
It's fairly clear that they didn't want to go through the normal rulemaking process. So I think there's two considerations there. There's the Administrative Procedures Act, and that's sort of your arbitrary and capricious rulemaking and all of those fun things. And then Dodd-Frank actually has separate requirements for rulemaking, which include a small business study, which obviously wasn't done here. And, you see how all this plays out with all of the CFPB rulemaking where it's been litigated for years. So obviously, I think they were trying to avoid that. But pertinent to your question, I mean, this feels like an actual amendment, I think, to both Mark and I. And just for example, I'm going to read the definition of credit card in both the Truth in Lending Act and Reg Z. So for the Truth in Lending Act, it's a credit card means any card, plate, coupon book, or other credit device existing for the purpose of obtaining money, property, labor, or services on credit. And then for Reg Z, it's very similar, but just to do this in a fulsome manner, I'll read it anyway. Credit card means a card, plate, or other single credit device that may be used from time to time to gain credit. So, I think if you had asked us or most industry practitioners a month ago what card, plate, coupon book, or other single credit device meant, we would have all said, almost to a T, other than another comment for open-end credit, that meant an actual physical device, right? You actually had to manifest something, whether it was on paper, on a card, on something in the physical world, not electronic, to constitute a credit card under both TILA and Reg Z.
And if I could just, build on that, there's these, and I'm not an expert at Latin, but, there's this concept of I think it's adjustem generis, of the same kind, class, or nature, kind of concept of statutory construction. And so when you look at what these words mean, like if I say, what is the plain meaning of card? I think people have an idea of what that means. It could be a business card, it could be a plastic card, but it's some physical device. And then plate, I think back in the old days, I remember my grandparents would call their credit cards like charge a plate or something like that. So I think, again, a piece of material that you could hold. A coupon book is certainly something that has a physical manifestation. And then, or other credit device. And I think when you interpret that list, when you look at that list, the catch-all, it's kind of like all those things need to be like each other. And so I think other credit device means also something tangible. And this all makes sense because I think the whole reason these rules exist are so if a consumer drops this thing, because, you can imagine if you drop a card, a plate, a coupon book, or a real device, physical device on the ground and someone picks it up, they can access credit with it. It's not the same with a digital user account. There can be many more fraud protections on that kind of account. And so I just don't think this makes any sense. And, we have some colleagues who are researching presently, the idea of whether, the kind of Administrative Procedures Act aspects of this. But, to me, this is like redefine. I mean, it's going beyond it. It's not even merely so not only is it's certainly not an interpretive rule. It's a lot more than that. And then I think it's a rule that directly contravenes the plain language of the statute. So even worse.
And Mark, just to belabor that point, I think, one of the things you could point to that, this is in line with what exists is comment 2, Roman 2C. And this is an exception for an account number tied to an open-end account that can make purchases. But even that, right, is like, I get this account number, I can go somewhere with it. There's no security or fraud protections. I can buy things. But to your point, a digital user account, most of the people that offer those, you have to log in, you have to have a password. There's a bunch of security steps that go in. It's not just something you can grab and start running around with and make purchases necessarily.
And so, Mark, Jason, it seems to me that given what you've just noted, and particularly if we have the idea of court deference to administrative interpretations of statutes going the wayside because of Chevron deference going away in the Loper Bright case, it seems like there's room for an argument here that the interpretation that's being used to support the BNPL rule may be arguably inconsistent with the Truth in Lending Act itself. What do you think about that?
Yeah, I mean, absolutely, Chris. That's my exact point with, looking at the TILA definition and then comparing it to this interpretive rule that basically reads into the TILA definition something that is not there, i.e. a credit card being something that doesn't have physical manifestation. So totally agree. And I think it'll be something that can be raised in litigation, I think, at some point.
Yeah, well, there's lots of that going around these days. So we'll see what happens in that regard. Let me just ask the final question that we have on our list for today. When did the CFPB set the compliance deadline for this new change it's made through this interpretive rule?
They've given us tons of time, Chris. July 30th of this year.
You heard that. That's in a very short period of time. It's less than 45 days from now. Yeah.
So is that is that feasible for buy now, pay later providers?
Yeah, I was just going to say, Chris, I think, to Mark's point, the CFPB has kind of stylized this as Fair Credit Billing Act protections. And even that, I think, would be nearly impossible. We've worked with clients in the past just on the policies and procedures around those. And many folks, I think, don't realize that that includes for every dispute that comes in. That means analyzing it for billing errors, unauthorized use, and potentially claims and defenses that Mark mentioned as well. So it's like a multiple step process just to do that. And I think that gets lost in the flux here a bit. But then also talking about all of those subpart B obligations that Mark was referencing, going through that list and trying to figure out what does or doesn't apply. And then, at a minimum, having periodic statements that sort of go hand in hand with those FCBA protections, account opening statements, all of that fun stuff. It's really, to me, it seems nearly impossible that anyone could do that in, 2 months' time.
Yeah, it seems that way to me too. And frankly, I've seen CFPB examinations of Fair Credit Billing Act compliance, and those are incredibly detailed in terms of all the things that are necessary to do it.
Yes, it's somewhat terrifying.
Yeah, definitely. Well, gentlemen, thank you for being on the podcast today to talk about this interpretive rule. We'll have to see kind of what happens from the industry's reaction standpoint. And Josh, thank you for co-hosting this episode of today's podcast with me. And of course, thanks to our listeners for tuning in to today's episode as well. Don't forget to visit and subscribe to our blogs, TroutmanPepperFinancialServices.com and ConsumerFinancialServicesLawMonitor.com. And while you're at it, why not go over to Troutman.com and add yourself to our Consumer Financial Services email list? That way we can send you copies of the alerts and advisories we send out, as well as invitations to our industry-only webinars. And again, check out our mobile app. Just search for Troutman Pepper in your app store and give it a try. And of course, stay tuned for a great new episode of both Payments Pros and the Consumer Finance Podcast showing up in your podcast feed. Thank you all for listening.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.